The morning I found the certified letter wedged in my mailbox, I was carrying a bucket of fresh goat milk in each hand and had mud caked halfway up my jeans from fixing a fence post that one of my Nubians had knocked loose. I set the buckets down on my porch and stared at the envelope with that familiar sinking feeling you get when you know something good is about to go sideways. The return address read, Meadowbrook Estates Homeowners Association, and those words alone were enough to make my jaw clench. My name is Isaac Dawson, and 6 months earlier I had purchased a 5-acre property on the outskirts of Willow Creek, Oregon, specifically because it was zoned agricultural and sat just outside the city limits. The house itself was modest, a 2-bedroom ranch-style building that needed work, but the land was perfect. Rolling pastures, good drainage, and enough space to finally start the goat dairy I'd been dreaming about since I worked on my uncle's farm as a teenager. I had spent the last 20 years working construction in Portland, saving every penny, planning every detail. This was supposed to be my fresh start. The thing is, when I bought the property, there was no mention of any HOA. The realtor never said a word. The title search came back clean. The previous owners, an elderly couple who had kept chickens and a vegetable garden, had lived there for 30 years without issue. But apparently, 3 years ago, the neighboring subdivision called Meadowbrook Estates had expanded, and their HOA decided unilaterally that my property and 4 others on my road were now part of their jurisdiction. They claimed something about aesthetic continuity and property value protection in their amended bylaws. I tore open the envelope right there on the porch. The letter was 3 pages long, printed on expensive-looking letterhead with gold embossing. It was from someone named Brenda Kensington, president of the Meadowbrook Estates HOA board. The language was formal and threatening, filled with whereas and heretofore, but the message was crystal clear. My goat dairy was in violation of the HOA covenants, conditions, and restrictions. I had 30 days to remove all livestock from the property or face legal action. There was also a demand for immediate payment of $1,500 in retroactive HOA dues dating back 3 years, plus another $800 in fines for various violations I had supposedly committed. I read through the list of violations twice, feeling my blood pressure rise with each ridiculous claim. Violation 1, maintaining livestock animals within the subdivision boundaries. Violation 2, operating a commercial business from a residential property. Violation 3, failure to maintain lawn aesthetics, as the pasture areas did not meet the HOA standard of manicured grass no higher than 3 inches. Violation 4, presence of agricultural structures, specifically my goat barn and milking parlor, which were not approved by the Architectural Review Committee. Violation 5, odor complaints from neighboring properties. I crumpled the letter in my fist and then smoothed it back out, forcing myself to breathe slowly. I had 16 dairy goats at that point, 8 Nubians, 6 Alpines, and 2 Saanens. I had just gotten my Grade A dairy license from the Oregon Department of Agriculture after passing a rigorous inspection. I had invested $40,000 in equipment, fencing, a commercial-grade pasteurizer, and a refrigerated storage unit. I had contracts lined up with 3 local restaurants and 2 farmers markets. My cheese was starting to win awards at county fairs. This was not some hobby I could just pack up and abandon. I grabbed my phone and called the number at the bottom of the letter. A woman answered on the 3rd ring with a voice that somehow managed to sound both syrupy sweet and condescending at the same time. Meadowbrook Estates HOA, this is Brenda speaking. Yeah, this is Isaac Dawson. I just got your letter and I think there has been a serious mistake. Oh, Mr. Dawson. She drew out my name like she was talking to a child. There is no mistake. Your property falls within our HOA boundaries, and you are in clear violation of multiple covenants. My property is zoned agricultural, I said, keeping my voice level. It was agricultural when I bought it. It has been agricultural for decades. I never signed any HOA agreement. The covenants run with the land, Mr. Dawson. When the HOA boundaries were expanded to include your road, all properties were automatically included. You should have received notification. I never received anything, and even if I had, you cannot just force someone into an HOA without their consent. That is not how property law works. Her voice turned cold. I suggest you consult with a real estate attorney if you have concerns about the legality. However, Joe, I can assure you that our bylaws were properly filed with the county and are fully enforceable. You have 30 days to comply, or we will file a lawsuit seeking injunctive relief and monetary damages. This is insane. I have a legal farm operation here. A farm? She laughed, actually laughed. Mr. Dawson, you live in a residential community. Your neighbors bought their homes expecting a certain quality of life. They should not have to smell goats or listen to animal noises or look at livestock when they are enjoying their backyards. I have received numerous complaints. From who? My nearest neighbor is half a mile away. That information is confidential. Now, I have been more than patient, but I have other matters to attend to. Good day, Mr. Dawson. She hung up before I could respond. I stood there on my porch, phone in hand, listening to the peaceful sound of my goats grazing in the pasture. In the distance, I could see the rooflines of the Meadowbrook estates houses, all identical beige stucco with terracotta tiles, arranged in neat rows like a suburban army. They were at least half a mile from my property line, separated by a county road and a dense line of Douglas fir trees. I needed help. I called my friend Marcus, who worked as a paralegal in Portland, and explained the situation. He was quiet for a long moment after I finished. Isaac, this is tricky. HOAs have a lot of legal power in Oregon, and if they properly filed their boundary expansion with the county, you might technically be subject to their rules. Even though I never agreed to it. Potentially, yes. But you said your property is zoned agricultural, right? Absolutely. That was the whole point of buying it. Then you might have an out. Oregon has pretty strong right to farm laws, and there are agricultural exemptions in the state statutes that can supersede HOA covenants. You need to talk to a real attorney, though, someone who specializes in property law and agricultural issues. He gave me the name of a lawyer in Eugene named Patricia Hernandez, who had handled farm-related disputes before. I called her office immediately and managed to get an appointment for the following week. In the meantime, I decided to do some digging of my own. I drove to the county recorder's office the next morning and requested all the documents related to the Meadowbrook Estates HOA. The clerk, a middle-aged man with thick glasses, pulled up the records on his computer and printed out a stack of papers. I sat at one of the public tables and started reading. The HOA had been established in 2018 when the subdivision was first built. The original boundaries clearly did not include my property or my road. But in 2022, they had filed an amendment expanding their boundaries to include what they called adjacent rural properties for purposes of maintaining community standards and property values. The amendment had been signed by the HOA board president at the time, someone named Gregory Thornton, and filed with the county clerk. There was no evidence that any of the affected property owners had been notified or had consented. I made copies of everything and brought them to my meeting with Patricia Hernandez the following week. Her office was in a converted Victorian house near the University of Oregon campus, filled with overflowing bookshelves and the smell of old paper. Patricia herself was in her 50s, with short gray hair and sharp eyes that missed nothing. She read through all my documents, asked detailed questions about my farm operation, and took extensive notes. Finally, she leaned back in her chair and smiled. Isaac, I think you have a very strong case. In fact, I think you might be able to shut this whole thing down. Really? I felt hope for the first time in days. Oregon Revised Statutes, Section 215.203 through 215.236 provide broad protections for farm use on land zoned for exclusive farm use or mixed farm use. Your property is clearly zoned agricultural. You have a licensed dairy operation. You are engaged in legitimate agricultural activities. Under state law, those activities are protected from local ordinances and regulations that would restrict normal farming practices. But what about the HOA? They are not exactly a local government. No, but courts have consistently held that HOA covenants cannot override state agricultural protection statutes. There is case law on this. The Oregon Supreme Court ruled in 2016 that agricultural exemptions take precedence over restrictive covenants when the property is properly zoned and the use is legitimate farming. The case was Miller versus Sunset Ridge HOA. Very similar facts to yours. I felt the weight lift off my shoulders. So what do we do? First, I am going to send them a response letter outlining the agricultural exemption and demanding that they withdraw their violations and their lawsuit threat. I will cite the relevant statutes and case law. With any luck, they will back down once they realize they have no legal ground to stand on. And if they do not back down, Patricia's smile turned sharp, then we bury them in court. She drafted a 10-page letter that same week, laying out in precise legal detail why the HOA had no authority over my farm operation. She cited Oregon Revised Statute Section 215.203, which defined farm use. She quoted from the Miller case. She attached copies of my agricultural zoning verification, my dairy license, and my business registration. She concluded by demanding that the HOA immediately cease and desist from any interference with my farming activities and withdraw all fines and fee demands. I thought that would be the end of it. I really did. I figured once they saw that they were legally in the wrong, they would back off and leave me alone. I had never been more wrong about anything in my life. 2 weeks later, I was served with a lawsuit. The HOA was suing me for declaratory judgment, seeking a court order that I was subject to their covenants and was required to remove all livestock and cease farming operations. They were also seeking $25,000 in penalties and attorney fees. Patricia called me the same day she received the complaint. They are digging their own grave, but this is going to get expensive and time-consuming. Are you prepared for that? I do not have much choice. This farm is everything I have worked for. Okay, then let's fight. The lawsuit was filed in Lane County Circuit Court. Patricia filed our response, which included not just a denial of their claims, but a counterclaim arguing that the HOA's attempt to enforce their covenants against my property was unlawful, violated my rights under Oregon's right to farm laws, and constituted harassment. We asked the court to issue a ruling that my property was exempt from HOA authority and to award us attorney fees. The discovery phase was brutal. The HOA's attorney, a guy named Martin Vickers, who wore expensive suits and oozed smug confidence, demanded every document related to my farm operation. They wanted my financial records, my business plan, my production logs, even my goat breeding records. Patricia explained that this was a fishing expedition, trying to find anything they could use to argue that my operation was not a legitimate farm. We provided everything they asked for because I had nothing to hide. Meanwhile, we demanded documents from the HOA. We wanted all the records related to their boundary expansion. We wanted the minutes from the board meetings where they decided to include my property. We wanted all the complaint letters they claimed to have received from neighbors. We wanted their financial records to see who was benefiting from this aggressive expansion of their authority. What we got back was revealing. The HOA had expanded their boundaries to include 5 properties on my road. Of those 5, mine was the only one still engaged in agricultural use. The other 4 had been sold to people who wanted rural estate properties and had either abandoned farming or never started. Those owners had apparently been pressured into paying HOA dues and following HOA rules without much resistance. My property was the last holdout, and Brenda Kensington had made it her personal mission to bring me to heel. The complaint letters were particularly interesting. There were 7 total, all written in the last 6 months, all using remarkably similar language. 4 of them were from residents of Meadowbrook Estates, whose properties were at least 3/4 of a mile from my farm. The other 3 were from board members themselves, including Brenda. The complaints talked vaguely about odors and noise and unsightly conditions, but provided no specific details. Patricia deposed Brenda Kensington on a rainy Tuesday in March. I sat in the conference room and watched as Patricia methodically took apart every one of Brenda's claims. Brenda was in her late 40s, with carefully highlighted blonde hair and a wardrobe that probably cost more than my truck. She spoke with absolute confidence, as if she were doing me a favor by explaining why I was wrong. "Mrs. Kensington, have you ever actually visited Mr. Dawson's property?" Patricia asked. "I have driven past it several times." "But you have never been on the property itself?" "No, that was not necessary." "How far is your home from Mr. Dawson's property?" "I live in Meadowbrook Estates on Sycamore Circle." "And what is the distance?" Brenda shifted uncomfortably. "I'm not sure exactly." Patricia slid a map across the table. According to this map, your home is approximately 1.2 miles from Mr. Dawson's nearest property line. Is that accurate? If you say so. Have you ever smelled any odors from Mr. Dawson's goats while at your home? Well, not at my home specifically, but when I drive past. With your car windows up or down? I do not recall. Mrs. Kensington, you submitted a written complaint stating that the odor from Mr. Dawson's farm was affecting your quality of life, but you just testified that you have never smelled anything at your own home. Can you explain that discrepancy? Brenda's face flushed. The point is that this is a residential community. We have standards. People do not buy homes in Meadowbrook Estates expecting to live near a farm. But Mr. Dawson's property is not in Meadowbrook Estates, is it? It is within our HOA boundaries. Boundaries that were expanded in 2022 without the consent of any of the affected property owners, correct? The board has the authority to amend our bylaws. Did you personally vote to expand the HOA boundaries to include Mr. Dawson's property? Yes, I was on the board at that time. And what was the reasoning behind that expansion? Brenda sat up straighter. We wanted to ensure that the properties surrounding our subdivision maintained appropriate standards. Property values are important. Were you aware that all 5 of the properties you added were zoned agricultural? I do not recall the specific zoning. Were you aware that Oregon law provides protections for agricultural activities on farm-zoned land? I am not an attorney, but the HOA has an attorney, correct, Mr. Vickers? Yes. Did you consult with him before expanding the HOA boundaries to include agricultural properties? Brenda hesitated. I do not believe he was involved at that stage, Patricia made a note. So the board decided to expand into agricultural properties without consulting an attorney about whether that expansion was legal. We were well within our rights. Mrs. Kensington, how much does the HOA collect annually in dues from homeowners? Each property pays $400 per year. And how many properties are in Meadowbrook Estates? Approximately 200. So that is $80,000 per year. What does the HOA spend that money on? Landscaping, common area maintenance, administrative costs, legal fees. How much are you personally paid as HOA president? Brenda's eyes narrowed. I receive a modest stipend for my time, $12,000 annually. $12,000. And when you expanded the HOA boundaries, that added 5 more properties paying dues, correct? Yes. So $2,000 more in revenue each year. This is not about money. Mr. Dawson's farm is incompatible with our community. Patricia leaned forward. Mrs. Kensington, is it not true that you personally own a property management company called Kensington Property Services? I do not see how that is relevant. Is it not also true that Kensington Property Services is paid by the Meadowbrook Estates HOA to handle administrative tasks? My company provides services, yes. How much does the HOA pay your company annually? Brenda's jaw tightened. $24,000. So between your stipend and your company's contract, you personally receive $36,000 per year from the HOA budget? My company provides valuable services. I am sure it does. No further questions. The deposition had been a massacre, but I knew the real battle would be at trial. The judge assigned to our case was a woman named Judge Ellen Morrison, who had a reputation for being no-nonsense and not suffering fools. Our trial date was set for June. In the months leading up to trial, things escalated. The HOA started sending me violations notices every week. One week they claimed my grass was too high. The next week they said my mailbox was not the approved style. They complained about my truck being parked in the driveway. They complained about my goats being visible from the road. Every single notice came with a fine, usually between $100 and $300. I kept every single one and forwarded them to Patricia. Then they started showing up. Board members would drive slowly past my property, taking pictures. One weekend, Brenda herself parked on the county road and sat in her Mercedes for an hour, just watching my farm. When I walked down to ask what she was doing, she rolled up her window and drove away. I installed security cameras after that. The harassment extended beyond me. The HOA contacted my restaurant clients and suggested that buying products from an unlicensed farm might expose them to liability. I had to send copies of my dairy license to reassure them. They filed a complaint with the County Code Enforcement Office claiming I was violating setback requirements. The inspector came out, verified that everything was in compliance, and closed the complaint. They even contacted the Oregon Department of Agriculture, claiming I was operating without proper permits. The department sent an inspector who reviewed my entire operation, found no violations, and sent me a letter confirming my compliance. Every attack just made me more determined, and every attack gave Patricia more evidence for our harassment claim. The trial started on a Tuesday morning in early June. The courthouse was a modern concrete building in downtown Eugene with high ceilings and fluorescent lights that gave everything a sterile feel. Patricia and I sat at the defendant's table, while Martin Vickers and Brenda Kensington sat across the aisle. The rest of the HOA board was there too, 5 people total, all dressed like they were going to a country club luncheon. Judge Morrison entered, and we all stood. She was in her 60s, with gray hair pulled back in a tight bun and reading glasses hanging on a chain around her neck. She got right to business. Good morning. We are here for trial in the matter of Meadowbrook Estates Homeowners Association versus Isaac Dawson. Counsel, are you ready to proceed? Both attorneys confirmed they were ready. Judge Morrison nodded. Mr. Vickers, you may present the plaintiff's opening statement. Martin Vickers stood and buttoned his suit jacket. He was in his 40s, with slicked back hair and a smile that never quite reached his eyes. Your Honor, this case is about the rule of law and the enforcement of valid contracts. When homeowners purchase property within an HOA, they agree to abide by certain rules. Those rules exist to protect everyone's property values and quality of life. The defendant, Mr. Dawson, purchased property that is subject to the Meadowbrook Estates HOA covenants. Those covenants clearly prohibit livestock and commercial farming operations. Mr. Dawson has refused to comply with the rules that bind all other property owners. He believes he is above the law. We are asking this court to enforce the covenants and require Mr. Dawson to remove his goats and cease his farming activities. Thank you. He sat down, looking pleased with himself. Judge Morrison turned to Patricia. Ms. Hernandez, your opening statement. Patricia stood, and I could see she was in her element. Your Honor, this case is indeed about the rule of law, but not in the way Mr. Vickers suggests. Oregon law is very clear that agricultural activities on agricultural land are protected. The state legislature has made a policy decision that farming is important, that farmers should be able to farm without interference, and that local regulations, including HOA covenants, cannot override those protections. Mr. Dawson owns property that has been zoned agricultural for decades. He operates a licensed, inspected, legal dairy farm. The HOA is trying to use their covenants to shut down that farm, but they do not have that power. Oregon Revised Statutes, Section 215.203, and the Oregon Supreme Court's decision in Miller v. Sunset Ridge make that absolutely clear. By the end of this trial, we will ask the court to rule that Mr. Dawson's farm is exempt from HOA authority and that the HOA's harassment of Mr. Dawson must stop. Judge Morrison made some notes. Thank you both. Mr. Vickers, call your first witness. The HOA's case relied heavily on the argument that their covenants were valid, properly filed, and enforceable. Vickers called a series of witnesses including the current HOA board members, a property appraiser who testified that farms near subdivisions could lower property values, and even a few Meadowbrook residents who claimed they were bothered by my goats. One of those residents was a woman named Cynthia Marsh, who lived on the far side of the subdivision. Vickers walked her through her testimony about how terrible it was to know there were goats nearby. Mrs. Marsh, how has Mr. Dawson's farm affected you? Well, I just think it is inappropriate. We moved here for peace and quiet, not to live near farm animals. Have you experienced any specific problems? I have heard the goats making noise. How often? Oh, multiple times. And where were you when you heard this noise? Well, I was driving past his property. I see. Have you ever heard the goats from your own home? Cynthia paused. I'm not sure. Maybe once or twice. When it was Patricia's turn to cross-examine, she pulled out a map. Mrs. Marsh, can you show the court where your property is located? Cynthia pointed to a spot on the map. Right here, on Willow Lane. And Mr. Dawson's property is here, correct? Patricia pointed to my location. Yes. That is approximately 1.5 miles away, is it not? I suppose. And there are approximately 300 homes between your property and Mr. Dawson's property, correct? I have not counted them. Mrs. Marsh, you testified that you have heard goats from your home, goats that are 1.5 miles away, separated by 300 houses, multiple roads, and a significant amount of trees. Is that your testimony? Cynthia's face reddened. Well, maybe I'm misremembering, but I definitely heard them when I drove past. With your windows up or down? I do not recall. Mrs. Marsh, you are aware that there are several other farms in this area, correct? Farms that have been here much longer than Meadowbrook Estates? I suppose. Are you also aware that there is a cattle ranch approximately 2 miles from your property in the other direction? I have seen it. Have you ever complained about that ranch? No. So you have no problem living near a cattle ranch with hundreds of cows, but you are bothered by Mr. Dawson's 16 dairy goats? It is different. The ranch was here first. And so was Mr. Dawson's property. It was zoned agricultural before Meadowbrook Estates existed. No further questions. The pattern repeated with every witness Vickers called. None of them had experienced any real harm from my farm. None of them lived close enough to be genuinely affected. They just did not like the idea of a farm existing near their subdivision. When it was our turn to present evidence, Patricia called me to the stand first. I explained how I had bought the property specifically because it was zoned agricultural, how I had invested everything into building a legitimate farm operation, how I had obtained all necessary licenses and permits. I walked through my daily routine, my business model, my relationships with customers. I showed pictures of my healthy, well-cared-for goats grazing in clean pastures. Then, Patricia established the legal foundation of our defense. She called an expert witness, a land use attorney named Professor David Kim, who taught at Lewis and Clark Law School. Professor Kim was in his 40s, with a calm demeanor and an encyclopedic knowledge of Oregon property law. Professor Kim, can you explain Oregon's agricultural protection laws for the court? Certainly. Oregon has some of the strongest farmland protection laws in the country. Starting in 1973, the state legislature created exclusive farm use zoning to protect agricultural land from being converted to other uses. The statutes, primarily ORS 215.203 through 215.236, provide that farming activities on farm-zoned land are protected from interference by local regulations. Does that protection extend to HOA covenants? Yes. While the statutes primarily address government regulations, Oregon courts have held that the same protections apply to private restrictions like HOA covenants. The policy rationale is that farming needs to be protected from external interference, regardless of the source. Is there case law on this issue? Yes, the most relevant case is Miller v. Sunset Ridge HOA, a 2016 Oregon Supreme Court decision. In that case, an HOA tried to prohibit a property owner from keeping horses and operating a small boarding stable on agricultural land. The court held that the HOA covenant was invalid because it conflicted with state agricultural protection statutes. The court stated, and I am quoting here, that legislative intent to protect farming activities cannot be thwarted by private agreements that seek to restrict those activities on properly zoned land. How does that apply to Mr. Dawson's situation? Mr. Dawson's property is zoned agricultural. He operates a licensed dairy farm. He is engaged in legitimate farming activities that are explicitly protected by Oregon law. The HOA covenant attempting to prohibit those activities is unenforceable. Vickers tried to poke holes in Professor Kim's testimony during cross-examination, but it was like watching someone try to push over a brick wall. Kim cited case after case, statute after statute, all supporting our position. The next witness Patricia called was the Oregon Department of Agriculture inspector who had recently visited my farm. His name was Robert Chen, and he had been a dairy inspector for 15 years. "Mr. Chen, you inspected Mr. Dawson's dairy operation, correct?" "Yes, in April of this year." "What were your findings?" "Mr. Dawson operates a clean, well-managed Grade A dairy. His animals are healthy, his facilities are sanitary, his record-keeping is meticulous, he is in full compliance with all state and federal dairy regulations." "In your professional opinion, is this a legitimate farm operation?" "Absolutely. This is a professional quality dairy farm. Mr. Dawson clearly knows what he is doing." "Have you received any complaints about Mr. Dawson's operation?" "We received one complaint from the HOA, which is why I conducted the inspection, but the complaint was baseless. Everything was in perfect order." Patricia then called several of my customers to testify. The chef from a farm-to-table restaurant in Eugene explained how my cheese had become one of their signature ingredients. The owner of a local farmer's market talked about how popular my products were and how I was always professional and reliable. These were not just character witnesses. They were establishing that I ran a real business, not a hobby farm that the HOA could dismiss as frivolous. The turning point came when Patricia called a surveyor named Linda Martinez to testify about the HOA boundary expansion. Linda had reviewed all the county records and created detailed maps showing exactly what had happened. "Ms. Martinez, can you explain what you found?" Linda displayed a series of maps on a screen. In 2018, when Meadowbrook Estates was first established, the HOA boundaries were clearly defined and included only the lots within the subdivision itself. In 2022, the HOA filed an amendment purporting to expand their boundaries to include 5 additional properties along County Road 47. However, none of those properties are part of Meadowbrook Estates. They are separate parcels with separate legal descriptions, and most importantly, they are all zoned agricultural, while Meadowbrook Estates is zoned residential. Is it common for an HOA to expand their boundaries after establishment? It is very unusual, and typically requires consent from the affected property owners. I could find no record of any notification or consent in this case. What is the significance of the different zoning? It suggests that these properties were never intended to be part of a residential HOA. They are in a different zoning category altogether, which typically comes with different rules and regulations. Vickers tried to argue that the HOA had properly followed procedures for amending their bylaws, but Linda's testimony had made it clear that the expansion was legally questionable at best. The trial lasted 3 days. By the end, Judge Morrison had heard from over 20 witnesses, reviewed hundreds of pages of documents, and listened to hours of legal arguments. On the final day, she asked both attorneys to present closing arguments. Vickers went first, trying to refocus on the idea that HOA covenants were binding contracts and that I had somehow agreed to them by purchasing property. He glossed over the agricultural exemption issue, probably because he knew it was his weakest point. Patricia's closing was methodical and devastating. She walked through every element of Oregon's agricultural protection statutes, cited the Miller case extensively, and pointed out that the HOA had never even tried to argue that my farming activities were not legitimate agriculture. She highlighted the harassment I had endured, the baseless complaints the HOA had filed with various agencies, and Brenda Kensington's financial interest in expanding the HOA's reach. She concluded by asking the court to not only reject the HOA's claims, but to issue a protective order preventing further harassment. Judge Morrison took off her glasses and looked at both attorneys. "Thank you both. I will take this matter under advisement and issue a written opinion. Given the complexity of the legal issues, I expect that will take approximately 2 weeks. Court is adjourned." Those 2 weeks were the longest of my life. I threw myself into farm work, trying not to obsess over the possible outcomes. I had already spent over $30,000 on legal fees, money I had scraped together by taking out a loan against my property. If I lost, I would lose everything. The farm, the house, years of work and dreams. But I also knew we had presented a strong case. Patricia had been brilliant, and the law was clearly on our side. I just had to trust that the judge would see that. The opinion came on a Thursday morning. Patricia called me at 7 in the morning, which immediately got my heart racing. "We won," she said, and I could hear the smile in her voice. "Isaac, we did not just win. We destroyed them. She read me the key passages from Judge Morrison's 30-page opinion. The judge had ruled that my property was exempt from HOA authority under Oregon's agricultural protection statutes. She had found that the HOA's boundary expansion was legally questionable, and that even if it were valid, it could not override state law protecting farming activities. She had dismissed all of the HOA's claims and granted our counterclaim, issuing an injunction prohibiting the HOA from interfering with my farm operation. But Judge Morrison had gone further. She had found that the HOA's conduct constituted harassment and had been undertaken in bad faith. She had awarded me attorney fees, meaning the HOA would have to reimburse me for my legal costs, and she had made specific findings about Brenda Kensington's financial conflicts of interest, suggesting that the board's actions may have been motivated by personal profit rather than legitimate community interests. I sat down on my porch steps, phone pressed to my ear, and felt tears of relief running down my face. Patricia, I do not know how to thank you. You already did. You stood up for yourself and you were willing to fight. A lot of people would have just given up and sold their property. You did not. So what happens now? Now we file for our attorney fees. I will draft a motion with my invoice attached. Based on the judge's ruling, I expect we will recover most, if not all, of your costs. The HOA has 30 days to appeal, but honestly, I do not think they will. This opinion is airtight. Will they leave me alone now? They have to. The injunction is clear. If they try anything else, they will be in contempt of court. I thanked her again and hung up. And then I walked out to the pasture where my goats were grazing in the morning sun. They looked up at me with those strange rectangular pupils, chewing thoughtfully. I had done it. I had protected them, protected my farm, protected my dreams. The attorney fees motion was filed 2 weeks later. Patricia submitted a detailed accounting showing that I had incurred $32,000 in legal fees and another $4,000 in expert witness costs. The HOA filed an objection, arguing that the fees were excessive, but Judge Morrison was not buying it. She issued an order awarding me $30,000, which was more than enough to pay off the loan I had taken out. The HOA did not appeal. Instead, something much more interesting happened. About a month after the trial ended, I got a call from a woman named Susan Whitaker. She lived on County Road 47, one of the other properties the HOA had tried to absorb into their boundaries. She had read about the lawsuit in the local newspaper. Mr. Dawson, I want to thank you. I have been paying HOA dues for 2 years because I thought I had to. I did not even know I could fight back. After reading about your case, I talked to my husband and we have decided to stop paying. We are going to cite your lawsuit if they try anything. Over the next few weeks, I heard from the other affected property owners. All of them stopped paying HOA dues. All of them cited Judge Morrison's ruling. The HOA's attempt to expand their empire had backfired spectacularly. But Brenda Kensington was not done yet. In August, I received a notice that the Meadowbrook Estates Board was holding a special meeting to discuss ongoing legal issues. The meeting was technically open to all property owners within their claimed boundaries, which technically included me, so I decided to attend. Patricia advised me to go and observe, but not to engage. The meeting was held at a community center within the Meadowbrook subdivision. I showed up in my farm clothes, jeans, and a work shirt that probably smelled like goats, and took a seat in the back row. There were about 40 people in attendance, mostly residents of Meadowbrook, who looked like they had wandered out of a catalog for upscale suburban living. Brenda stood at the front of the room, her face tight with anger. She called the meeting to order and immediately launched into a tirade about how the board had been betrayed by the legal system and how my lawsuit had endangered the entire community. Because of Mr. Dawson's selfish actions, we are now facing a financial crisis, she announced. The court has ordered us to pay over $30,000 in attorney fees. On top of that, we spent $45,000 on our own legal costs. This is money that should have been used for community improvements. Instead, it has been wasted because one man refused to be a good neighbor. A few people in the audience nodded along, but I noticed several others exchanging uncomfortable looks. Brenda continued, getting more worked up as she went. I am proposing a special assessment to cover these costs. Each property owner in Meadowbrook Estates will be assessed $500, due within 90 days. That got a reaction. People started talking over each other, voices rising. One man in the front row stood up. Brenda, with all due respect, this is insane. We are already paying $400 a year in regular dues. Now you want another $500 on top of that? For a lawsuit that we lost? We lost because the judge was biased, Brenda snapped. We had a strong case, but the court chose to prioritize one farmer over the well-being of an entire community. A woman in her 30s raised her hand. I read the court opinion. It is public record. The judge found that you expanded the HOA boundaries without proper authority and tried to shut down a legal farm operation. That does not sound like bias. That sounds like you made a bad decision, and now you want us to pay for it. This is not about bad decisions, Brenda said, her voice rising. This is about protecting our property values. Has there been any evidence that Mr. Dawson's farm has actually affected property values? Another man asked. The very presence of livestock is detrimental, Brenda insisted. But do you have actual data, comparable sales, anything concrete? Brenda ignored the question and tried to move on to other business, but the meeting had devolved into chaos. People were angry, and they were starting to direct that anger at her. I sat in the back, saying nothing, watching it all unfold. Finally, a man I later learned was named Richard Paulson stood up. He was one of the other board members, a retired accountant in his 60s. I think we need to address the elephant in the room, Richard said. Brenda, you have a significant financial conflict of interest. Your company receives $24,000 a year from the HOA. You personally receive a $12,000 stipend. Between your stipend and your company's contract, you are collecting $36,000 annually from the HOA budget. And yet you pushed for an expensive lawsuit without consulting the full membership. A lot of us have questions about that. Brenda's face went white, then red. How dare you? I have given years of service to this community. Service that you are very well compensated for, Richard shot back. I've been reviewing the financial records and I have some concerns. For example, your company billed the HOA $18,000 last year for landscaping services, but we also paid a separate landscaping company $15,000. Why are we paying your company for landscaping when we already have a landscaping contractor? Administrative oversight of the landscaping contract, Brenda said quickly. That does not make sense. We are paying you to oversee a service we are already paying someone else to provide? That is double billing. The room erupted again. People started pulling out their phones, probably looking up the financial records that Richard was referencing. Brenda tried to regain control of the meeting, but it was hopeless. Within 20 minutes, someone had made a motion to remove her as president and replace her with Richard. The motion passed almost unanimously. Brenda gathered her things and stormed out, shooting me a venomous glare as she passed my seat. I just nodded politely. Richard took over the meeting and the tone immediately changed. He apologized to me directly, acknowledging that the lawsuit had been a mistake and promising that the HOA would not interfere with my farm anymore. He also announced that he would be conducting a full audit of the HOA's finances and contracts, including Kensington Property Services. I left that meeting feeling vindicated in a way the court victory had not quite achieved. It was one thing to win in court, it was another to see the person who had caused so much trouble face consequences from her own community. The story did not end there. Richard's audit uncovered significant financial irregularities. Brenda's company had been overbilling the HOA for years, inflating invoices and charging for services that were never provided. The total amount was over $100,000. Richard filed a report with the Oregon Department of Justice Consumer Protection Division, and they opened an investigation. In October, I got a call from an investigator with the DOJ asking me about my interactions with Brenda and the HOA. I told them everything, provided copies of all the threatening letters and violation notices I had received. The investigator seemed very interested in the timeline of events, particularly how aggressively Brenda had pushed for the lawsuit. By December, the case had escalated. The DOJ investigation revealed that Brenda had not only defrauded the Meadowbrook Estates HOA, but had engaged in similar schemes with two other HOAs she managed through her company. The total fraud amount exceeded $300,000. She was charged with multiple counts of theft by deception and aggravated identity theft. I followed the case in the local newspaper. Brenda hired an expensive criminal defense attorney and tried to fight the charges, but the evidence was overwhelming. The HO, as she had defrauded, all cooperated with the prosecution, turning over financial records that documented years of inflated invoices and fictitious services. In March of the following year, Brenda accepted a plea deal. She pleaded guilty to theft charges and was sentenced to 18 months in prison, followed by 3 years of probation. She was also ordered to make full restitution to all the HOAs she had defrauded. Her property management company was dissolved, and she was barred from serving on any HOA board in Oregon. As for me, life went back to normal, or as normal as life on a working farm ever gets. My goat dairy continued to grow. I expanded my product line, added more farmers markets, and even started giving farm tours on the weekends. Kids loved seeing the baby goats, and their parents loved buying fresh cheese. The Meadowbrook Estates HOA, under Richard's leadership, became much more reasonable. They stopped trying to expand their boundaries and focused on actually serving their members rather than empire building. Richard even came out to visit my farm once, bringing his grandkids to see the goats. He apologized again for everything that had happened and told me that the lawsuit had been a wake-up call for the entire community. We got caught up in this idea that we could control everything around us, he said, watching his granddaughter bottle feed a kid goat. But that is not how the world works. You were here first. You are doing something valuable. We should have just left you alone. I appreciated the sentiment, and over time, I actually developed a decent relationship with many of the Meadowbrook residents. Some of them became regular customers at the farmers market. A few even asked about buying shares in my CSA program. The other property owners on County Road 47 also benefited from the lawsuit. None of them were actively farming, but they were grateful to have the legal precedent establishing that they were not subject to HOA control. One couple even started talking about getting some chickens now that they knew the HOA could not stop them. Looking back, the whole experience taught me that sometimes you have to fight for what is right, even when the odds seem stacked against you. The HOA had money, lawyers, and the weight of their bureaucracy. All I had was my farm, my determination, and a good attorney who believed in my cause. But I also had the law on my side, and in the end, that made all the difference. Oregon's agricultural protection statutes exist for a reason. They recognize that farming is essential, that farmland needs to be preserved, and that farmers should not be driven off their land by people who just do not like the idea of agriculture. Without those protections, places like my farm would disappear, swallowed up by suburban sprawl and restrictive covenants. I think about that sometimes when I am out in the barn at dawn, hearing the contented sounds of my goats munching hay and the milk machine humming. This is what I was meant to do. This is what my property was meant to be used for. And no HOA, no matter how powerful they think they are, has the right to take that away. The legal bills are paid off now. The farm is profitable. I hired a part-time helper to manage the increased production, a young woman named Emma Thompson who wants to learn the dairy business. She is smart and hard-working, exactly the kind of person farming needs to attract if it is going to survive. Sometimes tourists driving past on County Road 47 stop and ask if they can buy cheese or take pictures with the goats. I always say yes. I want people to see what a working farm looks like, to understand where their food comes from, to appreciate the work that goes into it. And maybe, just maybe, to think twice before they let their HOA bully someone just for trying to make an honest living. As for Brenda Kensington, I heard she got released from prison after serving a year. She moved out of state, somewhere in Arizona, I think. I do not waste time thinking about her. She made her choices and faced the consequences. That is all anyone can ask for. The farm is thriving. The goats are healthy and productive. My cheese won first place at the Oregon State Fair last year. I'm looking into getting a few cows to expand into cow milk cheese production. Life is good. Every morning when I walk out to start chores, I look at my land, my barn, my animals, and I feel grateful. Grateful that I had the courage to fight. Grateful for the laws that protected my right to farm. Grateful for Patricia and her brilliant legal work. Grateful for Judge Morrison and her fair, thorough ruling. Grateful for the community that eventually came around and supported me. This is my land. This is my livelihood. This is my dream realized, and no HOA will ever take it away.